Good morning.
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 Good morning. Great. So welcome to our virtual First District Court of Appeals. I'm glad you're able to join us this morning. So the only case that we have for argument today is Daniel Chertok versus Wallace Group General Dentistry. If each one of you can please identify yourself and also state your readiness to proceed.
Yes, I will start. This is Attorney Avante Campina-Bacote. I am the attorney for the appellant, Dr. Chertok.
Good morning.
Good morning.
And Mark Byrne on behalf of the appellant and appellee, the Wallace Group. And we're ready to proceed.
Okay, thank you. We're ready. You can go ahead and go forward.
Great. Before I begin, as a matter of procedure, am I allowed to reserve a few minutes for rebuttal at the end?
Absolutely. You can reserve whatever time that you would like.
Great. At this time, I'd like to reserve 3 minutes for rebuttal, please.
Okay.
Thank you.
And since there is a cross appeal.
Right, that
There
I was
is.
the judge, what was the procedure that the court wanted to use? Did you want Mr. Bacote to begin with his appeal and my response, then my response and his argument and response, or just argue both issues at the same time and allow a rebuttal? I just wasn't sure how the court wanted to move on this.
We can, because I believe that and pronounce your name again for me.
Campina-Bacote.
Campina-Bacote. Hopefully I got that close enough. Campina-Bacote.
That's good. Thank you.
Yeah. So you can go ahead first, and you were reserving how many minutes was it again?
3.
3 minutes. Okay. And then Attorney Byron, you can go, and we'll figure out at that point how, well, let me know how many minutes do you want to reserve?
I'll reserve 3 minutes.
Okay. And then we'll toggle back. All right. Okay. Attorney Campina-Bacote, whenever you're ready.
Thank you. Good morning. May it please the court. My name is Avante Campina-Bacote, and I represent the appellant, Daniel Chertok. The facts of this case are relatively simple. This case is about the appellant, Dr. Chertok, who was a dentist who engaged with the appellee, Miss Nancy Wallace, to purchase her late husband's dental practice. After months and months of communications, promises, and even a letter of intent that was fully negotiated amongst the parties and a price was set, Miss Wallace then backed out of the agreement, which resulted in Dr. Chertok losing thousands of dollars. And that is what prompted the initial filing of the lawsuit. So presented before this court is the trial court's award of attorney's fees in the amount of $2,200. And to be clear, that amount was limited to the issue of unauthorized practice of law that came up via an amendment in the lower court, and I'll explain more about that. But it is the appellant's position today that that award of attorney's fees of $2,200 is not appropriate, given the fact that the counsel for the appellant, which was myself, the only reason why that issue was brought before the court was because of an unauthorized practice of law by the appellee, Miss Wallace. And in other words, it is inappropriate for the trial court to award fees for an attorney to simply carry out their duties as an attorney, which is to uphold the law and to report misconduct and violations of the Ohio rules of professional conduct.
Let me ask you a question, if I could. Had that already been brought to the attention of the court? Had she already stricken the answer purported to be filed on behalf of the corporate entity before you attempted to amend the complaint?
I believe so, yes. And procedurally what had
So
happened
she
was,
already knew that the individual couldn't represent the corporation and had dealt with it in an appropriate manner.
yes, I believe so. I still don't believe that relieves an attorney of their obligation just because the court addresses something. The court is just one of the mediums in which that is to be addressed. One of the things that was done in this case was, in addition to bringing it before the court via a motion to dismiss, it was also brought before the ethics board. The hotline was called, and there was advice that was given to that it was perfectly acceptable to bring that attention to the court the way that it does here, which was via an amendment or an attempt to amend it. So I would
That's
argue.
not part of our record, is it?
I believe it is. It is through the transcripts that were submitted towards the hearings, one of the two hearings. It was testimony that was given about the steps that were taken to put this before the court. And it was also in the briefing as well, Your Honor. But it's appellant's argument that absolutely, was this before the court in some fashion? Yes, one of the first things that was done was a motion to dismiss was filed to address this. And I would also like to note that the trial court was mistaken, even though it was ultimately dismissed. It was the trial court's position that this is something that's routine and acceptable, that non-attorneys such as Ms. Wallace can file on behalf of their corporation or their entity, and that's obviously not the case. But
Can I interrupt you again and ask one more question? Let's
Sure.
assume that you had procedurally done what you needed to do to file a private cause of action
Sure.
for unauthorized practice of law. What was the damage to your client that you were seeking by attempting to bring that private cause of action?
Attorney's fees. There were, just as the appellee here is claiming that they were damaged by, a couple $1,000s for having to brief motions related to the unauthorized practice of law, equal is here. Significant time was spent briefing and filing motions to dismiss on that case, reply briefs as well. So it's not significant in terms of, tens of thousands of dollars, but it's the exact same thing that the appellants are claiming here, which was attorney's fees associated with having to essentially litigate that portion.
And the reason why you were not able to ultimately bring that claim was because the Supreme Court had not made a finding prior, right?
That is correct. It's because there was a prerequisite of the Supreme Court to make a determination of that before you could file a separate cause of action. And I personally was unaware of that requirement. I'm not sure of too many attorneys who are. This is a unique issue of bringing up a UPL issue mid case, but that is correct. The reason why was because the prerequisites to filing a private cause of action had not been satisfied yet.
And the court accepted, my understanding is the court accepted that you were not aware of that that's not really at issue. But my understanding is the court ultimately said by looking at the statute, it's clear that that was a prerequisite. And that was part of the determination with regard to the finding saying that it was not warranted under existing law. How would you address that?
I would address that the award of fees that came from essentially attempting to prosecute that was deemed that it was frivolous on behalf of counsel or the appellant to attempt to do that. And as we know, and as the statute defines, defining something as frivolous or sanctionable is something that requires intent or bad faith, maliciousness. And I would argue that that simply wasn't done here. It was a simple oversight. The counsel for appellant attempted to amend the complaint to address what he believed was a rightful violation, which was a documented violation of unauthorized practice of law. And just as litigants and their counsel have time and time again made procedural missteps with filing, for example, a lawsuit before, if there was a mandatory arbitration clause in a contract, or somehow proceeding in a case without satisfying all of the elements of a claim, it was no different here, Your Honors. There was simply one prerequisite which was not met before filing, which was acknowledged and admitted. But does that equate to frivolous conduct that's sanctionable and under the statute? I don't believe so.
And my reading of the judge's decision is another basis is that she made a determination that that attempted filing was served merely to harass. So how would you address that part of it?
Right. Again, I would say that there was no evidence of intent or maliciousness. Again, it is true that the court had in a way addressed the proceduralness of the procedural inappropriateness of the motion to dismiss in the UPL issue. But again, just because the court addresses something a certain way doesn't mean there's other avenues to pursue things. And as I mentioned here, the issue here was not about whether or not a separate action could have been filed for the unauthorized practice of law. If the Supreme Court had certified it, that claim would have been completely appropriate to bring before the court. So when taking a look at what was frivolous, what was malicious, it's the fact that was there any intent or knowledge that, okay, there is a requirement that needs to be satisfied before you can bring this cause of action. I know about that. I'm going to disregard it, and I'm going to intentionally file this lawsuit or try to add this claim to rack up attorney's fees and to do so inappropriately. So I think you have to look at the underlying nature of the claim, and there was nothing inappropriate or wrong about the filing of an unauthorized practice of law claim for a non-attorney to violate those rules. And that's exactly what happened here. Further, I would say that there wasn't the amount of time that it took to address this issue was very minimal. I think it was literally 14 days, 2 weeks. It was a motion for leave that was filed, and that was quickly desponded of, and that's why the attorney's fees were so low here, $2,200, because there was very little time that was taken. So to address the potential maliciousness, I would say that there was there's a lack of knowledge on the attorney's part that there was this requirement, and that cannot be said to be malicious or in bad faith.
Are you aware of any cases where the Supreme Court of Ohio has certified as the unauthorized practice of law the attempt by the sole shareholder of a closely held corporation to file an answer on behalf of the company?
No, and I will admit that, at least in my research, that this is a novel issue. I frankly couldn't find many cases at all about an attorney or a non-attorney being, not only sanctioned, but filing a motion like this in this context. And that is why one of the first things that was done before a motion to dismiss was filed or before an attempted amendment was made was to call the Ohio Board of Ethics. They have a hotline, and they routinely, as we all know, assist with practitioners or with hypothetical questions on topics that might not be top of mind or easily researchable, or at least that can cross that line and into ethical or non-ethical conduct. And that's exactly what I did. I called, sought advice, and the advice that was given was that it's perfectly acceptable to address this with the courts, whether that was through a motion.
Can I ask you a very specific question? Was the advice that it's appropriate to bring it to the attention of the court, which the court apparently already knew about it, or was the advice that it's appropriate to file a private cause of action in the case for unauthorized practice of law?
I can't recall, Your Honor. I know for sure the first question was asked with respect to filing a private cause of action. I was aware of that through research that, again, through my personal experience about filing UPL claims and whatnot, but whether or not it was appropriate, I don't know if I asked if filing, a private cause of action, because if I did, there would have been a conversation about that prerequisite about it being certified, which I was unaware. So to be honest, I don't know if that second question was asked, but I do know I asked in general about addressing with the court. And to me, my understanding was that was via it could be via a filing, that could be via a notice, that could be via an amendment, that could be via any type of court filing, which is what I did.
Thank you.
Thank you, counsel.
So another issue that was a couple issues that were brought up on appeal is,
Do you still want to reserve your 3 minutes?
oh, am I over my time?
You're there.
Oh, okay, great. Then I will stop then.
Okay, thank you.
Good morning, Your Honors. I'll address the first issue that the court discussed with Mr. Campina very quickly. The statute's clear that the trial court had no jurisdiction in this case for an unauthorized practice of law case. The way that this issue came up is that originally the Wallace Group filed motions to dismiss in the municipal court. The municipal court indicated that the amount of controversy was over the jurisdiction. The case was bumped up to common pleas court. It was rolled to Judge Giz. Judge Giz ruled on the motions to dismiss and denied them. Afterwards, in November of 2017 or 2016, then an answer was filed. A lot of things occurred in 2017. And then in 2018, counsel for Dr. Chertok files this motion for leave on January 2nd, 2018, in which to add an unauthorized practice of law claim. In my reply, opposition memorandum, I indicated in that opposition memorandum that the trial court had no authorization to go ahead and hear this claim, that the statute was clear. Simply by opening up the statute, a reasonable lawyer could have seen that the trial court had no jurisdiction and could not proceed forward or grant the amended complaint because the Supreme Court has to rule on the issue first before any subsequent motion can be filed. That was
Mr. Campina Bacote brings up a good point, and that is like you have situations where people have, whether it's a contract or collective bargaining agreement, and there it says it has to go to mediation or arbitration, and they forego that and go straight to the Court of Common Pleas. You have all these different situations where it's, where it's readily available and discernible that there's some fault before, that's clear in the cause of action. So on all of those causes of action, would the opposing party be entitled to attorney's fees?
Well, I would answer that two ways. First of all, if in fact there's a contract that has an arbitration provision, if in fact there's a contract that has a mediation provision, usually there's a form selection clause in that contract also, which would require, if you're going to file a lawsuit based on a controversy, you file it in a certain court. That's not the case here. And because there was no jurisdiction for the trial court. Secondly, in the opposing memorandum, we brought to the attention that you can't file this claim, that you need to withdraw the claim because there's no jurisdiction. Dr. Chertok and his counsel decided to go forward anyway, knowing that there had been pointed out to them that there was no jurisdiction for the court to go forward. That caused the reply to be filed. And then finally, Judge, they acknowledged it in their reply that they knew they couldn't bring the claim, but continued to go forward with the claim and actually came into town and had a hearing on a claim that they know and that were told and acknowledged they could not go forward on. That's why the Judge Giz in this case decided that it was merely to harass, because when you're told you can't go forward on it and you do so anyway and acknowledge it, that's frivolous conduct under the statute.
And where in the record is that acknowledgement?
That would be TD 36 at page 2, trial document 36, page 2, which is the reply. And his motion, the motion was trial document 33, page 3, and then we filed a response, which I think was 34, 35, telling him that you can't bring this claim. Brings it anyway, and then has a hearing, and the judge goes ahead and denies it. And then during a hearing on May 9th, during the sanctions hearing, counsel agreed that the motion to amend the complaint was properly denied by the court. That's the trial transcript, May 9th, page 94, lines 16 to 19. So when you take all those together, when you file something that you can't, when you're told that you can't file it, you continue to go on, you acknowledge that it was granted, it should have been granted. I think that meets the quantum level for 232351. And that's why the court went ahead and granted the attorney's fees. So I'll put that issue aside. And what I want to talk about is her denial of the attorney's fees in this entire case, because this case is about one person who's a dentist that attempted to buy a dental practice, being upset, and then his lawyer, which is Avante, and Dr. Chertok, filing a lawsuit that should never have been brought in the beginning. They brought a lawsuit when they all knew, and the record is replete with examples of this, that any of the causes of action that in this particular case that were brought in their complaint were frivolous, were not supported by any evidence, nor a good faith extension of any applicable law. And they proceeded to go forward on that solely in effort to go ahead and leverage $5,500 from a woman that didn't make any deal at all. They asserted 4 causes of action. One was a breach of contract based upon an unsigned letter of intent that both the plaintiff and his counsel acknowledged before the filing was unenforceable. A negligent misrepresentation claim that both counsel and his client acknowledged that there were no representations that were made that they relied upon in engaging these business negotiations. The third was a promissory estoppel claim, which they all acknowledged the promissory estoppel claim was not applicable because the letter of intent that was unsigned in this, 3 of them in this entire case, indicated that unless the letter of intent signed, you can't rely upon anything that's contained within the document itself. And in fact, Dr. Chertok indicated he knew that he couldn't proceed with any claim unless there was a written contract for the sale of the assets. And finally, they executed or filed a complaint for the violation of the duty of good faith and fair dealing, which the law is clear that that's not a separate count. So all 4 of these counts, when they were filed, everybody knew on the other side that they did not have any evidentiary support, that in fact the documents that were relied upon in the complaint were unsigned, indicated that they couldn't be relied upon against signed, and each of these documents that they relied upon had a sunset provision that had occurred without any of the documents being signed to go ahead and culminate these business negotiations. Throughout this case, I sent letters to the other side indicating to them that you can't go forward on, once I was retained, that going forward on these claims is frivolous.
Are those letters part of the record?
They are. They were made part of the record in the February 21st, 2019 hearing. And there was at least 3 occasions where letters were sent or emails were sent saying you can't go forward on this. What we did find out was during the hearing, when counsel did not show up on the first time on February 21st, that Dr. Chertok was not told about any of these offers of settlement during the course of these proceedings. So when I showed him the emails, when I showed him the letters, he says, I had no idea that this was going on. That was one of the things that Judge Gibbs became upset about, is that there are these negotiations going on that counsel is not going ahead and communicating to his client. Those are the type of things that were going on. So when we filed the motion for the sanctions in November of 2018, we set this for hearing on February 21st, 2019. Dr. Chertok has separate counsel. Avante doesn't show up. And what he indicates, he didn't show up because he didn't know about it. And in memoranda that he files with the court on March 14th, 2019, he says that statements made by counsel for the Wallace Group, which is myself, and the judge, that he knew about the hearing were false. So we set another hearing, and it's that hearing where just a culmination of things where counsel gets up on a stand and acknowledges that he knew about the hearing, but didn't have time to prepare and didn't show up. Those are all the type of things that are going on here. So
another lawyer showed up for that, right?
another lawyer showed up and represented Dr. Chertok during that hearing. So all of the things that were argued in the brief for Dr. Chertok, that 1, he didn't know about the hearing, 2, didn't have a chance to object to the attorney's fees, 3, that there was testimony that should never have been given about the mediation. The lawyers were there, didn't object, and they took all of this evidence, including the $48,000 in attorney's fees that were incurred in defending this case without objection. And
In
those-
light of what you just said, were you seeking fees against the client and counsel or only counsel?
both,
If the client didn't know, well, if the client didn't know,
client didn't know
was
about the
going on?
offers. Yeah, the client did, sorry, Judge, the client didn't know about the offers of settlement. The client did know that there was no plausible causes of action that could be brought in this case. And in fact, the client testified without objection that he had discussed these issues with Avante before filing the lawsuit and was told that some of these causes of action are going to be thrown out and that you don't have a written claim or a written breach of contract claim against the Wallace Group. Yet they still filed those and pursued them after being told on numerous occasions that this is wrong, you can't do it, and if you don't dismiss at the end of the case, we're going to file for sanctions. And
Did
that's,
he testify that when he was appearing pro se at the beginning of the case, that his lawyer actually ghost wrote the complaint for him, or that he just conferred with his attorney?
no, the testimony on February 21st was that all of the pleadings were written by Avante and that the complaint was written by Avante and ghost written. He indicated that he's a dentist. He doesn't have the legal acumen to go ahead and to put that complaint together, and indicated that he had done no research before he filed the lawsuit. The only thing he did know is what his lawyer told him is that a lot of these things you're not going to be able to win on, you're not going to be able to go forward on, and yet they filed him anyway. And
But there's a difference between not winning and having a weak claim to frivolous conduct. Do
Judge,
you agree with that?
I would agree with that, Judge. And as you know, I've been doing this just a little bit shorter amount of time than you have. I've been doing this now 37 years, and I have not ever been to the Court of Appeals on a frivolous lawsuit claim. Tried over 100 jury trials. I have never gone this far on this type of claim. But when you enter into a situation where, and the email is clear, Judge, there's an email that I received back from Avante in 2017 where I said, hey, we need to go ahead and resolve this. I got the email back that stated in substance that it doesn't matter. We're going to go on with this for years. If you don't like it, that's too bad. And that's the way it is. We're not going to go ahead and stop, even though they were told you can't go forward on this.
Counsel, you'd like to reserve your 3 minutes?
I would, unless.
Okay, if there's any further questions, we'll definitely take them.
Let me just
Judge Myers,
ask one quick
absolutely.
question. Would it be possible, Mr. Byrne, that there was a claim, a contract claim, an agreement to agree, and that bad faith, good faith and fair dealing would have entered into that agreement? In other
Well, you'd
words,
have
there
to-
is law that says there can be an agreement to agree. Now, whether it's enforceable, that's another question, but is that, I'm not sure it was pled that way. In fact, I don't think it was, but
It was not pled that way, Judge, but I would say to you this, I have never seen a case in my legal career which would pass muster where the agreement to agree is part of a letter of intent that says, unless there's a signed document, there is no agreement whatsoever. In other words, you can't put blinders on and say we have an agreement to agree when we have a document that says we can't agree unless there's an execution of the document and a subsequent later in contract. So I would agree in a totally oral situation, but not when you have 3 letters of intent that are passed between each other, lawyers involved, and when the client says, I know that I don't have an agreement unless the document's signed. That's the distinction, I believe, from the line of cases that you've referenced there.
thank you.
Thank you.
Thank you, Your Honor. Just a few things to address. The first is, please keep in mind that the appellants here, the appellees here, they did file a motion to dismiss on all claims. The court on multiple times in both the municipal court and the common pleas court addressed the substance and the merits of all of plaintiff's claims here. Sure, the case was voluntarily dismissed prior to trial, but not a single claim was dismissed, and an analysis was gone through when, Mr. Attorney Byrne brought his entire amount of fees before the court. And the court evaluated each claim and whether or not it was frivolously brought, if there was any merit or justification. And the determination was that all of those claims were properly brought. In addition, Mr. Byrne had the opportunity to file a motion for summary judgment. No motion for summary judgment was filed on any of these claims. The case literally proceeded to trial until a couple weeks before the actual trial date. So to claim that there's no merit or that every single claim brought was frivolous is a wild overstatement. I would certainly argue that sure, some claims may have had more merit than the other, like a promissory estoppel claim or the good faith and fair dealing, but every claim, including the contract claim, was determined by the court to be not frivolous, which again is an extremely high standard. In my over decade of practicing, I've never been sanctioned before any court or deemed any claims been frivolously filed. Of course, claims will get dismissed, but to call them frivolously brought is a completely different standard, which has not been met here. I do want to also address the knowledge of Dr. Chertok. I reside in California, I still do, and that is why another attorney was hired, or why some of the hearings were done telephonically in this case. But keep in mind that at the second hearing, the most recent hearing in the trial court, these questions were re-asked to Dr. Chertok, and it was made clear, as the record indicates, that he was aware every filing in this case was passed along to Dr. Chertok. I can personally state that because I was the one who did it. In terms of every communication, settlement offer, the one letter saying you should dismiss this case or we're going to seek sanctions was forwarded. So there was complete knowledge by the plaintiff here of the filings in this case and whatnot. The ghostwriting, sure. Did I as Dr. Chertok's attorney, prior to noticing my appearance, assist with the filing? Of course. And I think it was also acknowledged that Mr. Byrne himself, or at least an attorney, did the exact same thing for Miss Wallace through those motions to dismiss that were filed. There were several months of litigation that happened before any of the parties represented, and then the attorneys jumped in around the time that it was transferred to the Common Pleas Court.
Was there was there depositions and discovery in this case?
There were, yes.
Okay.
Yes.
And that's after the lawyers got involved?
Correct.
The depositions?
Yes, that is correct. And both were represented by counsel during those depositions. Correct. The one point I want to bring up as well is that, again, I think that standard of being frivolous is an extremely high standard that has not been met. I'm not aware of any type of additional hearings or what knowledge brought to my attention of, once it was had to be certified, that there was any additional prosecution. Simply days after that was brought or the reply was filed, the court acknowledged it, just as the motion to dismiss, when it was brought to the defendant's attention that, hey, you can't file this claim. Was there a voluntary withdrawal of that motion to dismiss? No, there was not. The court simply determined that, just like it did with this issue. But even if there was some merit to awarding fees, I think the court is absolutely clear that a lodestar method must be done in order to properly award fees. And what is woefully absent from the judgment entry, from the award of fees, is the fact that there was no lodestar done. There was no acknowledgement of the reasonableness of the hours. There was literally just a few check marks on Mr. Byrne's attorney, fee statement, saying this, we're going to count this, moreover.
I'm sorry to interrupt. Doesn't the judge have the ability to review the detailed billing invoices and make that determination? Isn't that what courts do all the time with submission of fee requests?
Yes, but by law, that has to be explained in an order. You can't just, sure, was there a statement submitted to the court? Absolutely. Did the court review it? Yes. But the law is clear under, I believe it's Bittner and a couple other cases, that there has to be an explanation of the reasonableness in those fees, and that lodestar method has to be documented. And that simply was not done here by the judge. And moreover, the appellant's attorney, myself, was unable to object to that. And that's the whole purpose of due process, constitutional rights, is having an opportunity to object to the reasonableness of the fees, such as the billable rate, the hours spent, and none of that was allowed here.
I thought that you were not at the hearing when the fees that initially were presented, and so it was a different lawyer, and they didn't.
Correct. I was not at the first hearing, and that was part of another appellate issue about the fact that that hearing proceeded due to some inappropriate ex parte communication, and the fact that I was not notified properly of that hearing, which is why it was missed.
Right,
So the second,
I'm saying that your client was represented by counsel there, and that counsel did not object.
right,
the
that is correct. My client was represented in a very limited fashion in that hearing, and it was someone just to cover the hearing, and didn't do anything. I think it was literally just to defend the cross-examination at the hearing, but there was no affirmative defense or objections that were put on by the attorney. So it was a very limited representation. And again, that was part of the issue I took. And I believe why a second hearing was called was because of the lack of notice of his primary attorney and the fact that there wasn't an objection that was able to be made to those fees. So.
And then at
And
the second hearing, did you object?
Yes, and that is documented in the transcript.
Okay.
Yes.
And I don't, this might not be a fair question in the sense that it's probably not part of your argument, but is it your position that $2,200 is unreasonable?
I do still think yes. In light of the entire
And again,
amount,
I don't really expect you to answer that because you haven't had an opportunity to test some
Correct.
of those issues at a hearing. So I think you've answered all I needed to know.
yeah,
Thank
it's the billable rate. I think is one thing too. This type of a case was not the type of cases, subject matter that Mr. Byrne does, and to charge $400 an hour for a pretty simple contract case when that's not someone's area, I think is excessive.
Thank you.
Thank you. Attorney Campina Bocotes, unless there's any other questions. Okay,
Thank
thank
you.
you for your argument.
Thank you, Your Honors.
Judge, I just want to follow up with a couple of things. One is, you are correct on the February 21st hearing, Avante just didn't show up. So the fee bills were entered. I testified as to the reasonableness and necessity of all the fees. The judge listened to the testimony. There was no objection, and they were admitted as exhibits without objection. For Avante to say that he didn't have the opportunity to object is somewhat misguided, because once he did show, the reason for the second hearing is because of his March 14th memorandum, in which he indicated that the court falsely said he didn't know about it. And that's not true either. So when he came back on May 9th, we there for the hearing, he took the stand, the court adjourned, I left, I got a call saying, hey, they're back, they want to object to the attorney's fees. By the time I got back to the courtroom, this isn't in the record, they were told that the documents and the attorney fee bills had been entered, and everybody walked away. To say that Dr. Chertok didn't have the chance to go ahead and object to the attorney's fees bill is just not accurate. One of the things I would also point out too is that Avante says that Dr. Chertok was told about everything. If you look at page 8 of my brief, I took testimony right out about the offer to go ahead and walk away. Dr. Chertok testified that, one, he was unaware of the offer to walk away that occurred in April of 2018 until February 1st. That's in the trial transcript, page 38, 2-8. Nor was he aware that Bocote had rejected the offer without consulting him beforehand. That's February 21st, 38, 9 through 11. So to say that in this particular argument that Dr. Chertok was told everything is just not accurate. And then
Well, it might be accurate. People might have different memories.
they may have different memories. I can only pull out what is in the transcript. And to say that you didn't attend because you didn't know about it, Avante took the stand on May 9th and admitted that he knew about the hearing, but he said, I wasn't going ahead and told appropriately. We also entered in the February 21st, the notice from the assignment commissioner of the hearing, and he had discussions with his client about the February 21st hearing and just didn't show up. I would say that in this particular case, Judge, everybody goes through business negotiations. But when the business negotiations are not fruitful and they don't consummate in an agreement, that doesn't mean that it's open season on suing the other side for the expense that have been incurred on causes of action that have no merit. And that's what 2351 in part was enacted to stop, this type of litigation. I talked about the email.
Well, how do you address the argument that this survived Civil Rule 29?
The way I would address that argument, Judge, and that there was a 12B6 motion that was filed by Avante before I became part of the case. In other words, the Wallace Group and Mrs. Wallace had gone ahead and filed a motion to dismiss. As you know, Judge, under 12B6, the court is required to go ahead and construe the allegations as true. So the court did what it was supposed to do, construe the allegations in the complaint as true, and deny the motion. But there was never any determination that they had merit other than being on the face of a complaint. Once we took the depositions, once we got into the evidentiary issues, once Dr. Chertok testified that I knew that these had no merit, I was told they had no merit, but we went forward anyway. Then at that point in time, it became apparent that you can't go forward. And that's why 23-23-51 is set, to let one side know the other side, hey, let's stop this now. Let's stop incurring additional fees. Let's get this off the court docket and allow other cases that have merit to go forward and not take up time.
But no summary judgment motions were filed. This
There were
was
no-
just going to go to trial.
Yeah, and there was tactical reason for that. One is we didn't want to incur any additional expense. And two, as the court knows, there's a different standard of review on a summary judgment motion versus facts that are entered in during trial. In a summary judgment motion, it's a de novo review on a question of facts or review of facts or determination of facts. It's whether there's an abuse. So my client decided to go ahead, didn't want to incur the cost on a motion for summary judgment based upon the knowledge that back in summer of 2019, that there's no merit, let's go to trial, let's get this over with, and let's not go ahead and litigate on a summary judgment motion.
Thank you, counsel. Unless there's any other questions. Thank you for your arguments this morning.
Thank you, judges.
We will take the matter under submission and issue a timely decision. Have a wonderful afternoon.
Thank you, Your Honors.